3 new criminal laws, significant changes and key concerns. A petition was moved in Supreme Court on June 27, seeking a stay on the implementation and operation of 3 new criminal laws: Bhartiya Nyay Samhita 2023, Bhartiya Nagrik Suraksha Samhita 2023 and Bhartiya Sakshya Adhiniyam 2023. All these new criminal laws are scheduled to come into effect from July 1, 2024. The writ petition filed by Anjali Patel and Chaya Mishra, represented by advocates Sanjeev Malhotra and Kumar Siddharth, has urged the Apex Court to constitute an expert committee immediately to assess the viability of 3 new laws, which overhauls the criminal procedure and justice system and replaces the Indian Penal Code (IPC), the Code of Criminal Procedure (CrPC) and Indian Evidence Act. The plea highlighted that 3 laws were passed without detailed debate and effective discussion in the parliament, as a large number of members from the opposition were suspended. Hello and welcome to this new episode of Forum Review. In this video, let's talk about the controversy surrounding the 3 laws, the extraordinary powers given to the police under them, and the concerns over the potential misuse of these codes. The process to overhaul the criminal justice system in India commenced in May 2020, when the Centre constituted a panel called the Committee of Reforms in the Criminal Law to recommend reforms in the British-era statutes. This committee's report culminated in the promulgation of the 3 bills that were first introduced in the Parliament in August 2023 during the monsoon session. This move took most parliamentarians by surprise, as the 3 bills were added to the list of business for the day through a supplementary agenda. Introducing the 3 bills, Union Home Minister Amit Shah said they fulfill one of the Panch Prans or the 5 vows announced by the Prime Minister Narendra Modi on August 15, 2022 to erase all the signs of British slavery. The bills were then referred to the Parliamentary Standing Committee. After incorporating certain changes, the government reintroduced them in the lower house on 12 December 2023. The passage of the laws had its own share of controversy that were approved in the absence of more than 140 members. The MPs that were not present belonged to the opposition bench and were suspended following protest over security breach in the parliament. The laws were passed with a voice vote in the lower house and then unanimously in the Rajya Sabha. Bhartiya Nagrik Suraksha Samhita or BNSS, replacing the Criminal Procedure Code, will now have 533 sections. The Bhartiya Nyay Samhita or BNS, which will replace the Indian Penal Code, will have 356 sections instead of the earlier 511. Bhartiya Sakshy Adhiniyam or the BSB, which will replace the Evidence Act, will now have 170 sections instead of the earlier 167. Some noteworthy changes introduced are provision for trial in absentia, which means a criminal trial will not stop due to the absence of an accused. The time limit for plea bargaining, which according to the new law would be 30 days of the crime. A 30-day deadline to produce documents amidst others. The laws also introduce community service as punishment. This appears to be in line with the judicial orders, where courts have imposed community service as punishment, even though it is not prescribed in the now archaic IPC. Such punishments have ranged from planting trees to carrying out traffic duties or working with an NGO. Community service as a form of punishment aims to rehabilitate first-time offenders in petty offences and adopted as a measure to address overcrowding of prisons. The new penal code does not criminalize adultery and homosexuality. A quick reminder here, both these laws were declared unconstitutional by different constitution benches of the Supreme Court. By not including them in the new criminal laws, the government rejected the Parliamentary Standing Committee's suggestion to reinstate adultery and also to retain that part of homosexuality law in IPC that made non-consensual sexual intercourse between 2 persons of the same gender illegal. However, concerns have been voiced over wide powers given to law enforcement agencies and addition of terrorism without proper safeguards against the possible misuse of authority by the police. Greater executive control could lead to indiscriminate surveillance, caution human rights activists. Let's take a look at some of the key changes introduced in the penal legislations that have sparked worry among jurists and activists. The first point of contention is the extended reach of police custody. Following an arrest, the person is either remanded to police custody or judicial custody until the investigation is complete. An accused is kept in police custody if any recovery has to be made at his or her behest. During this period, the accused is made to stay in a police station or lockup. Judicial custody is detention by judicial magistrate, during which the accused is kept in central or state prison. Depending upon the nature of the offence under the probe, the police have either 60 or 90 days to complete their investigation. As per the current legal framework, in the first 15 days of detention, the custody can be changed from police to judicial and vice versa. It can also be intermittent. The new law, however, allows detention in police custody for 15 days in whole or parts at any time in the first 40 or 60 days out of 60 or 90 days that are the two timelines fixed to complete the investigation. This means the window period to seek police custody is no longer limited to first 15 days of the arrest, and it can be taken in later stages of the probe, making the accused more vulnerable to police excesses. In such an arrangement, the chances of an accused getting bail will also shrink, as courts are more receptive to releasing a prisoner during judicial custody now, with the possibility of the accused being sent to police custody at any point during the investigation. Courts would be reluctant in granting bail until the probe continues. The new laws officially do away with sedition, but with the inclusion of new provision, sedition will continue to haunt through a different definition. If you recall, the Supreme Court in May 2022 had temporarily suspended the sedition law mentioned in the Indian Penal Code. The stay on its operation came in the backdrop of allegations over its misuse. The petitions challenging sedition in the current form were referred to a constitution bench of the top court. However, the replaced criminal law, which is BNS, restores sedition is an alternate form. Though the word no longer exists in the law, the concept is retained with a more broad and vague definition. Experts fear this vagueness in the law would give scope to the police machinery to abuse it further, vitiating free speech rights and leaving no room for dissent. Acts that are endangering the sovereignty, unity and integrity of India would get covered in this new provision, unlike the outdated sedition law where the penalty would be limited to fine. The new section, which is 150 of the BNS, mandate imprisonment under all circumstances. This jail term can be anywhere between 3 and 7 years. Another area of contention is the recognition of electronic communication as a means to commit alleged act of endangering sovereignty and unity of India. Worryingly, BNS absorbs terrorism and organized crime. Experts are astounded with the absorption of special offences that are currently governed by special legislation such as Unlawful Activities Prevention Act of 1967, popularly known as UAPA, which deals with terrorism, and the Maharashtra Control of Organized Crime Act 1999, or MACOCA in BNS, as ordinary crimes. However, the Section 113 of BNS lacks procedural safeguards that exist in UAPA and MACOCA to prevent alleged fabrication of cases. For instance, UAPA requires government sanction and independent examination of evidence to prosecute an accused. Besides, the definition of terrorist act under the new law is vague. Any act likely to threaten the unity, integrity, sovereignty, security or economic security of India, or any act which could strike terror in the people, will be treated as crime under the new section of 113 of BNS. In contrast, in UAPA, an act has to be violent act to be considered as a terrorist act, but the new penal code could potentially be used to target peaceful non-violent acts if they meet the criteria mentioned in the law. The new definition also includes any act that threatens the economic security of India as terrorism. The new law also gives the police unbridled power to decide whether to proceed under the UAPA or Section 113 of the BNS. Such enormous discretionary authority to a superintendent of police level officer could embolden the law enforcement agencies to invoke the new statute in order to bypass the little safeguards contained in the special laws. Police getting wide powers to seize digital evidence under the new law have raised concerns over breach of privacy of citizens. Reworked with a clear objective to digitize most aspects of the criminal procedure from registering an FIR to drawing the charge sheet and even writing judgments, the laws would give formal legal sanctity to include digital evidence in the criminal justice system. Until now, courts did conjoined readings of two laws, that is the Evidence Act and Information Technology Act, to ascertain whether the digital evidence presented by police is valid or not for a trial. But with the new laws, summons can be issued electronically and testimonies from witnesses, experts, accused and other parties may also be presented electronically or virtually. Definition of documents has been expanded to include electronic or digital records, including online communications on various personal devices that would cover instruments such as mobile phones, laptops, cameras, and other electronic gadgets. Police can now search for any material or document without a written order if they have reasonable grounds to believe that such material or document cannot be otherwise obtained without undue delay. This could now extend to electronic devices and online communication. In the absence of any procedure to ensure security or maintenance of a proper chain of custody for such digital evidence and adequate safeguards, experts have questioned the free hand given to the enforcement agencies to acquire such information. Concerns have been raised over possible tampering, leaks as well as breach, particularly because digital evidence would now be treated as primary and not secondary evidence. This would legitimize and encourage infringement of privacy by the executive experts have warned. Further, the laws allow the court to summon any document or material necessary for an investigation as evidence, including the digital evidence from a person who is in the possession but is expected to produce the same or is not directly involved in the trial. This is all that I have for you right now with regard to the three new criminal laws that are going to be introduced and implemented from 1st of July 2024.